Full session on direct and indirect tax regime, the global era, the new global era of international taxation. And Mr. Datar made a wonderful suggestion today. We have legal luminary Arvind Datar, renowned advocate who practices in Delhi High Court and Supreme Court, Mr. Ved Jain, former president of the institute as well, who chaired the session. Sir, you spoke about a need for a new DTA for indirect taxes. That's a new thought.
Yes, after seeing the OECD guidelines, after seeing all the BEPS action plan, I thought all the problems which have been highlighted can be resolved only if there is a bilateral treaty between countries. As a start, we should have a DTA with our major trading partners, which will prevent double taxation and which will give certainty to what is place of supply, what is consideration and so on and so forth. So all the controversy can be substantially resolved for indirect taxes, just as DTW has helped in direct taxes. It will also help for indirect taxes.
You mentioned about the place of supply as being a major problem. Was that in the context of the Indian GST, or you're talking generally with the global indirect tax regime?
What happens is there is a tendency, what's called competitive policies, where each country tries to define a place of supply to be its own country.
Yeah.
Like we will say if the recipient is in my country, I'll say my country also. So this creates a huge distortion where the same tax becomes payable in 2-3 countries. Like if you say ocean freight is taxed in Germany, again taxed in India, and then when the person pays an Indian tax, he doesn't get credit on the inputs going in. So it's a major problem on place of supply.
Jain sir, want to add to it?
No, he's absolutely right. There is a challenge on this issue, and that can be resolved in case there can be double taxation avoidance and quickly on the way we have in direct tax.
When you have two senior counsels, I can't but not ask you about the tax litigation. One heartening fact, sir, is that considering the backlog of income tax cases in the Supreme Court, you are seeing a plethora of judgments on the income tax side from Supreme Court, though many of them are not assessing friendly. But generally, on the tax litigation side, do you think the Supreme Court has finally woken up to the need to clear up this income tax backlog?
Well, it's not that they have woken up. Now we have got 34 judges or 30 plus judges. So there is a possibility of having tax matters being posted before more than one bench. Yes, but I think the solution is not creating more benches. The solution is to stop unnecessary litigation, like the multiple reopening of assessments. As Mr. Jain said, the socio-economic growth, you have a provision for socio-economic growth, like a backward region or something. And then the department tries to keep on disallowing on some pretext or the other. Like you have a treaty, and despite having a tax residence certificate, that is ignored. So many cases where just demands are made contrary to the law, and nobody is accountable. Nobody hauls up a person. I'm doing a case where one of the largest companies in the world, they say your tax residence certificate is not clear or this is not acceptable. Now, say for example, engineering analysis, it has settled the software issue.
And there is a review petition now.
No, review, apart from review, today it is
the law of the land.
Law of the land. But you simply make a demand contrary to the judgment, and when we reply, you say that your argument is untenable. So a lot of litigation can be avoided at the level, as I keep on saying for 1,000 times, as long as there is revenue targets, it is going to, the litigation will continue unabated.
Yeah, just 1 second. Jain sir, litigation at the Delhi High Court. Which are the burning issues that are still unresolved?
No, coming back to the issue which you are asking to the senior advocate, Arvind, see, the idea is not to only clear the backlog what we are having, to ensure also that we do not create the law. See, what pipeline should be created. I think that's why the law should be clear and the law should be accepted the way it has been enacted by the parliament. What happens is in interpretation or in over-enthusiasm, we try to have an interpretation which becomes revenue friendly, and then we have a lot of litigation. The Supreme Court disposes a matter, and then a large number of cases come back again. So again, we are clogging the system. To declog the system, we make the law very simple. As regards the recent controversy in the High Court, we see tax litigation is on the maximum. And the reason being the recent amendment made by the Finance Act 2021, and which has created a lot of controversy.
On reassessment.
On reassessment particularly, somebody has to sit down and apply the mind whether this new law which we have enacted is what intended for the purpose, which the way it is being interpreted. Each and every assessment can be reopened mainly for the purpose of re-verification only, because the law says income escaping assessment. You need to have first crossed this hurdle that there is a material sufficient which suggests that income has escaped assessment. It is not a case where you have income verification. What is being interpreted now by the tax administration is that simply I want to re-verify so I can issue a notice. And that's why again you will clog the system and litigation will go on.
Last question.
And one more thing to supplement what my colleague Mr. Jain says, you create huge litigation and suddenly you say all cakes below 2 crores I will delete. for low tax effect. Now you make the person litigate, and then by putting a 2 crore limit, again you create some unhealthy system. What's the point in creating litigation? Because first 10 lakhs, 50 lakhs, 1 crore, 2 crore. Tomorrow you will have another 30,000 cases, and you'll say anything below 5 crores I will delete.
Sir,
Yeah.
sure. So last question, sir. Can't let you go without asking this. Your comments on the Supreme Court judgment on charitable institutions.
Well, frankly, I'm happy that at least my argument for the Institute of Chartered Accountants prevailed, and they have got a charitable status.
On the ratio itself.
Otherwise, the mood will be very gloomy today. Yes.
So what will be the fate of tomorrow's?
No, no,
But according to me, I think the judgment has not fully resolved the issues on general GPUs of general public utility. It is going to create more complications, and I think now, by virtue of the Supreme Court judgment, it will be very, very difficult for a GPU to retain its charitable status, because if you keep the 20% limit, no GPU can survive, because very often the income comes from activities. Now, the point is, if I'm a GPU, suppose for example I'm running a self-help group of women and I make agarbattis or I make papad or something like that. Now, it is a thing, the work is done to give employment and some relief to these destitute women. What the proviso intended was, if my main charitable object is making women work for some cause, and I do some other business, that extra business should not be 20%. Now, what you say is the very GPU itself should not generate more than 20%. It's going to be very paradoxical. I think unless legislature steps in, a large number of GPUs are going to be very badly hit. In fact, some people are going to say, why have a charitable trust at all?
We have a headline for tomorrow.
See, the idea, why we give an exemption to charitable trust? Why in the
promote charity?
No, why? Because we believe the objective which we can do by collecting taxes and then going back to the people to provide that money which we collected taxes can be achieved through other media, that is the NGO. NGO in India are playing a very human role and responsibility. Whether it is a tsunami in Chennai, whether it is the earthquake in Bhopal, whether it is a COVID, these NGOs have played a very effective role.
Yeah.
And now that's why they need to be handled very delicately. And the way this complex law is being made and the way the Supreme Court has interpreted, now it is for tax administration to come back again and realize the role of the NGO and to make out necessary correction, as my learned friend is rightly pointed out. It will be very difficult for anybody to having a general public utility to get an exemption, the way it has been interpreted. So meaning thereby it is awakening call for a tax administration also and for the government of the day that we NGO have to play a very important part in the Indian social fabric, because these are the NGO which came out to the rescue when COVID and all these people were roaming around and food was not available, shelter was not available. And now and these are not being organized by well-trained professionals. To comply with this type of interpretation and strict law the way it has been interpreted, it will be a challenge to the NGO.
Last words.
My view is on charitable trust is going to be a huge problem. As long as the revenue generated by any activity is applied for charitable purposes, it should not be taxed. And anyway, your limit is you have to apply 85%. You can accumulate. Section 11 restrictions are there. So why do you get into further thing of this 20% limit, which has to be deleted accordingly?
That was Mr. Arvind Datar and Mr. Ved Chair on the sidelines of the 21st World Congress of Accountants at the picturesque state-of-the-art Geo World Convention Center. Thanks so much, sir, for your time.
Thank you.